The most rewarding aspect of my practice is not only the personal satisfaction of intellectually challenging myself, but also having the additional payoff of that challenge benefiting someone else, especially someone who's in need or has been taken advantage of, often by someone, a corporation, a company, with much more power, much more resources. Sometimes I analogize it to endurance sports that I've done before, like trail running or rowing, where in the moment you have your personal satisfaction of pushing a mental limit or a physical limit, and that in and of itself is sort of the reward of what you're doing, regardless of whether you win or not. But unlike that, and with law, you have those same challenges and those same moments where you're pushing those limits, but every time you push the limit a little bit more, someone else benefits from that. And having those two things align is very satisfying. One of the most memorable cases I've handled involved title insurance, and it was still within our area of bad faith, but this is one of those cases that takes you to a slightly more unusual area of the law. And for me, that was title insurance. And this case in particular involved determining whether legal access existed to my client's property. And that task involved analyzing decades-old maps and really old and what I would call ancient documents that describe land. I felt like at times I was the only person who believed in our theory, and there were many moments where I had to essentially learn someone else's profession, like civil engineering or surveying, and then argue with someone else, a surveyor or a civil engineer, about the case. So that was a very unusual situation that I had never been in before, sort of doing a crash course in someone else's profession and then arguing with them. But eventually, when the court agreed with our theory of legal access, and this was after years of building up this theory, it was one of the more satisfying moments of my career.